Ladies and gentlemen, welcome back to the Indie Zone podcast. My name is Kathy. If you have been following this podcast since episode 1, where we addressed the very first filing on the court docket when this case was opened back in December of 2022, we have very frequently expressed our opinions under the First Amendment of the United States Constitution, freedom of speech and of the press, of the unexplained secret nature of this case, where, for example, all discovery requests and all discovery responses, although the requests and the responses themselves appear on the public docket, the crux of what was asked for in terms of evidence in the discovery request and what has been responded to in terms of evidence in the responses, those exhibits have all been filed under seal. And I urge you to look at the case summary page in Idaho versus Koberger. Go back to page 1 and you will see just how many requests and responses to discovery have been filed under seal. You will also see that there has never been a single motion that either side, the state or the defense, ever filed to unseal even partially any of the multiple discovery requests and responses to be made public. So in other words, both sides have wanted all discovery in this case, every single bit of evidence, to be under seal. And we see 2 more examples filed on April 15th, 2025. The first is motion to seal defendants' responses to state's Exhibit S's in SAM 1, to state's first supplemental request for discovery. Comes now, Brian C. Koberger by and through his attorneys of record, and hereby moves the court for an order to seal the defendants' responses to the state's Exhibit S's in SAM 1, attached to their first supplemental request for discovery. If we go on to page 2, you will see that this motion is made pursuant to ICAR 32I and IC 741241B and C because they are either previously already sealed or are redacted. Dated this 15th day of April 2025, Ann C. Taylor and Taylor Law. And you'll see here on page 2 that there is an explanation as to why this additional document should be under seal. Ms. Taylor is stating specifically that these documents here are either previously already sealed by the court or are redacted. If you look at multiple of the motions to seal discovery and responses thereto by both sides, while they'll give legal authority, such as here ICAR 32I and IC 74124, one is a rule, the other is a statute. In many of their requests to seal, there's no explanation as to how the documents before the court meet the criteria of law that entitles the documents to be filed under seal. Go to the case summary page and look at the documents that are corresponding on the docket where the request for sealing of discovery is located. You will see that many of them do not give an explanation as this one does, including the next one that I'm going to now address. This is motion to seal Exhibit E as in Edward, to defendants' 5th supplemental response to discovery. So what this is following is 4 prior responses to discovery where exhibits A, B, C, and D were also requested to be filed under seal. Here we see, comes now Brian C. Koberger by and through his attorneys of record and hereby moves the court for an order to seal Exhibit E as in Edward, to defendant's 5th supplemental response for discovery. We go to page 2. This motion is made pursuant to ICAR 32 IC, section 741241B and C, dated this 15th day of April 2025. So here we see another example where, although a request for discovery to be filed under seal is made, there's no explanation given why this meets the criteria of law to have yet another document related to discovery filed under seal and therefore outside of the public arena. This is Kathy. Thank you for joining us here today.